Welcome to this free immigration help channel. Today is May 22nd, 2023, and we are getting into the volume 97 of me answering your immigration related questions. As you can see, I have all of them pulled up in front of me. As always, before starting this video, I'm going to mention I am not an immigration attorney. This is not a legal advice. All the information provided in these videos on this channel are directly from official government sources like USCIS and of course the Department of State with their Visa Bulletin. So let's start with the very first question from Evgenia Dniprova. I'm waiting for the decision almost 4 months for how long I can stay in US. Thank you. So the question was on the video I-539 for the extension or change of status. So that's a really good question, Evgenia. Thank you for asking. So whenever it comes to I-539, let's actually go to USCIS and because I'm curious how long these applications typically take on as of right now. Because the last time I checked, they were taking close to a year, which is quite a ridiculous number. Why? Because most of the times our duration of stay that we get, as we come into the United States of America as non-immigrants is 6 months, all right? So if you're here for, 3-4 months and you decide that you have to stay longer in the United States than 6 months, you submit this application for the extension of stay and then you wait a whole year to get the answer. If that's the case, it means that in 2 months, you will be outside of that duration of stay. Yes, you do have a pending change of status, extension of stay request, but nevertheless, you are outside of the duration of stay. And that creates, of course, a problem. So before we go any further, let's go and check the processing times for these. You can get there a few ways, but that's how I get them. If you get the uscis.gov tools at the very top of the navigation menu, then you click on case status online. And hopefully it doesn't take forever to load this time, because for whatever reason this page, it takes a while. Application is currently not available. Great, so it looks like they're doing some kind of updates. So we're gonna go back to tools and we're gonna go to USCIS tools and resources. That's another way you can find this. Case processing times, here we go. That's another way, and it looks like this page is working. So we're gonna select I-539, application to extend, change non-immigrant status. Category, I'm not sure, Evgenia, what your category is, so I'll just select the most popular, probably, non-immigrant, visitor, tourist, visa, B, B1, B2. We're going to select that. Depending on which processing service center your application is being processed at, obviously the amount of time we're waiting is going to be different. So let's select California first, and just to kind of get, okay, so 13 months, just a little bit over a year. Let's check Nebraska. 25 months. Wow. So over 2 years in Nebraska, and then Texas. Wow. So this one is 2 years. So California is, wow, 31 months. Okay. So obviously it's going to take longer than the duration of stay that you have. You will be outside of the status. So my recommendation is, if you have to stay in the United States, if it's an emergency and you just cannot go outside of the United States and come back, maybe your duration of stay already passed the 6 months or the 3 months or however long your duration of stay was. If that is the case, then absolutely you have to remain in the United States and wait for the decision from USCIS. Most of the times they approve these extensions of stay. So once you get the approval, that's really it. Everything going to be fine. Again, the way it works is usually they approve, which is also ridiculous. Honestly, it is ridiculous. They approve. So let's say you wait for a whole year, right, for your approval of that extension of stay. You filed it obviously a whole year ago. After a year, you get the decision that your extension of stay was approved for another 6 months. But it's approved for another 6 months from the time you have applied for that. So by the time you get it, you're already 6 months outside of that duration of stay. Now, it does not mean that you are going to be going into that inadmissibility clause where now you are remaining in the country illegally. No. Why? Because you had that extension of stay pending But at the same time, keep in mind that once you receive the decision, you will have to leave the United States, show this paper in the airport showing that it was approved. They're not going to count it as overstaying the duration of stay, but nevertheless, you won't be able to remain in the country longer than that unless you file another petition. Horrible process, and I'm sorry if what I said is a little bit confusing, because it is quite ridiculous. It makes absolutely no sense. Hopefully they will be able to resolve that pretty quickly. But Evgenia, my recommendation is, if you are still within those original 6 months, within that original duration of stay, and you did not go past it, if it's not an absolute emergency for you to stay in the country, it is much better to just abandon this application, leave, and then come back again and get the new. It takes away all the risk, because still the risk remains that the application might be denied. All right, most of the times, like I said, they are not. Most of the times they are approved, but still there is a chance that it might be denied, and you definitely don't want to be in a situation where you received a decision for the I-539 and they did not approve, and you're already outside of your original duration of stay. Alrighty, so let me put this. If you have any follow-up questions, and everybody who's watching, if you have any follow-up questions, if something is unclear from what I said, please do not hesitate to ask as many questions as you have. Just please make sure not to respond to my comment within your comment, because then I do not see those notifications. Just submit a separate comment and I will see it on this wall. Alright, let's move on to the next one from Game Changer. Hi, do you know why USCIS didn't release interview letter for May 2023 India? Last release date was 14 April 2023. Game Changer, I have a follow-up question for you. Can you please let me know which interview letter you exactly are referring to? If you can, please provide a link in a separate comment, and I'll check on it, and I'll try to answer your question. But as of right now, from your comment, I thought that you're referring to Visa Bulletin, but doesn't seem like that's the case. So please let me know what you're referring to, and I'll check on it. So let me put this, and we're gonna move on further to Beetle Churros. Hello, are the questions for I-730 interview similar to the I-130 interview? Thank you for your info. Thank you very much for your question. That's a great question. Yes. So I-730 and I-130 are practically exactly the same process, except I-130 is for US citizens and permanent residents petitioning for their relatives. I-730 is for those people that have been granted asylum who are petitioning for their children. Most of the times it's under 21. In some situations they make exceptions for kids that are over 21 and for the spouses. So the process is going to be very similar. The petition is very similar. The wait time is a little bit better, but again, there is some wait time involved. I've seen these cases take 2-3 years, but the interview is going to be very, very similar in the questions, because really what they are doing is they are establishing a few things. They're establishing the intent to immigrate to the United States, and of course they are establishing the relationship. So if we're talking about spousal relationship, in those situations, that's where the questions, let's just say, become elaborate. All right, they're very easy to answer if the marriage is the real deal. That's why these questions are designed that way. They're basically to verify that the marriage is a legitimate marriage and not a fictitious marriage, because unfortunately whenever it comes to marriages, the field of immigration is very rich with elaborate scams and frauds that people do. Unfortunately, that's the negative side of the immigration when it comes to people and not the government. But like I said, if there is no fraud involved, that's going to be very straightforward, very simple. There's not going to be any problems. Alrighty, so let's put this, and we're going to move on to the next one from Man Brar. I filed petition under F3 category for India leaving children on September 2010. How long I wait more? Alrighty, man, thank you for your question. Let's take a look. So we know India, F3. Let's scroll down to graph B first, dates for filing. Basically, that's when the priority date is when the petition was submitted to USCIS, the I-130 petition. And then the graph B is showing which priority dates are now being getting the full access to the NVC portal to become documentarily qualified. The graph A shows when the immigrant visa is becoming available for those who are already documentarily qualified. So let's start with the graph B. F3, India. Looks like India and all charge is the same as all chargeability area, as you can see. February 10. So no different. So let's see, February 10, and you have your petition September 2010. Okay, so February 2010, September 2010. We have like 7 months. So 6-7 months. So man, you've done quite a lot of waiting. 7 more months roughly before you have a full access to the NVC portal to become documentarily qualified. For you, I would highly recommend checking out a video on this channel. I have it. It's called this video right here. Documentarily qualified, what does that mean? Check out that video. In that video, and for everyone who has I-130 petition and they are waiting to become documentarily qualified, they're in that process of getting there closer to that where the NVC portal opens up and you can submit all the stuff. Check out that video. I highly recommend it. In that video I show an actual NVC portal that was documentarily qualified, so you can see all the applications that you need to submit, which is immigrant visa application, DS-260, and then the affidavit of support, how much they are, the fees that you have to pay, the civil documents, financial documents that you have to submit. So if you were close to that NVC portal, like Man right here, 6 more months, and he will have the full access to the NVC portal. Start preparing all of the documents so that once it opens up, immediately you can log in, 2-3 days, submit everything, you're documentarily qualified within a few months, and that's it. Then you're just waiting for the immigrant visa to become available. Alrighty, let's move on to the next one. Actually, let me put this before I forget. And we're gonna move on to the next question from Lambo. Thanks for this amazing Q&A sessions. You're very welcome. Thank you for watching. I have a question. Which way is a faster way for my siblings? My parents, oh, there's more. Let's click that. My parents, permanent resident holders sponsoring their above 21-year-old children. Okay. Me, US citizen, sponsoring my siblings who are above 21 years old. My parents, PR holder, and I, US citizen, applying for half and half at the same time. Okay, Lambo, that is excellent question. Really, really good question. And it shows, I think it will show a lot of people that there are options. There are options that are better, much better than some other options. So let's start with the number 3. There is really no point of submitting it half and half. There is really no point because one side is going to be waiting much less than the other side. So this one is going to be processed much faster than this one. So let's go to the second one. It's you petitioning for your siblings as a US citizen. And interestingly, this is the 4th priority category, which takes the longest. So if we're going to take a look at the Visa Bulletin, and we are already in graph B, actually we can even look at the graph A because we have the full picture basically of how long these petitions take. So F4, brothers and sisters of adult US citizens, 4th priority category, for all chargeability area. So that is if you are in any of the country, if the beneficiary is any of the country other than China, India, Mexico, or Philippines. These 4 countries, they have their separate chargeability areas, and some of them different, much longer processing times. So we're looking at all chargeability areas. We have April 2007, which is roughly 16 years. So if you petition Lambo for your brother, sister, for your siblings as a US citizen, you will be waiting roughly 16 years before the immigrant visa will become available for them, which is ridiculously long time. But now moving further to the option number 1, your parents as permanent residents sponsoring their above 21-year-old children, that would get us into the F2B category, which is the 2nd preference category. Unmarried sons and daughters 21 years of age or older of permanent residence. And F2B is showing September 2015. That's people with the priority date in September 2015. Their immigrant visa as of May 2023 is now becoming available, which makes it about 8 years. So 16 years versus 8 years. That is half. and half faster. Still a long time. 8 years to wait is still a long time, but it's definitely not 16 years. So I definitely recommend option 1 for sure. Lambo, that was a great question. This never came up on this channel. I can't believe this never came up on this channel. But for everyone who's watching, that's one of the reasons why I started these question answer videos, because you're dealing with different cases, and sometimes you are, I myself am learning a lot of stuff from answering these questions. Let me put this before I forget. We're gonna move on to the next one from Jen Raid. Jen, by the way, thank you very much for being publicly subscribed to this channel. I really appreciate it. This is what this icon means. So Jen says, my F2A is moved to F2B. Under what circumstances they do that? My priority date was February 16, 2016. Oh, Jen. Okay, so I think what might have happened is that most likely, I'm pretty sure that's the case. 99% sure this is what happened. You have petitioned, if you are the petitioner, or you're the beneficiary. If you're the petitioner, you have petitioned for your son or daughter who were under 21. As a permanent resident, when you petition for your son or daughter under 21, they are in F2A category. Your son or daughter, they reached 21 years old, and then the NVC or USCIS, usually it's NVC, that they update stuff like this pretty quickly, because they're the ones who are dealing with the visa categories. They have updated, because now your son or daughter beneficiary over 21, they have updated the category from F2A to F2B. And F2B, I was just talking to Lambo about F2B, that is unmarried sons and daughters 21 years of age or older. And if you are yourself a beneficiary, then I'm thinking your parents petitioned for you, you were in F2A because you were under 21 and you have reached 21 years old, and then now you're in F2B category. So I want to say, sorry that you're dealing with this. This is completely unfair. I think it's completely unfair because it shouldn't be like this. The whole aging out, this is what they call it. This is what NVC, Department of Homeland Security, that's what they call it. I think the whole idea of this is ridiculous. Why? Because these petitions, they do take a long time. They do take a really long time, and it's not because of our fault. It's not because of immigrants. It's because of the government agencies that decided that they need to have this limited number of immigrant visas available for the families that reside in the United States of America. And that is unfortunately the case. So if you have filed your petition and you were, let's say, 15 years old back in, somebody petitioned for you 5 years ago, 6 years ago, and it took a long time, because it takes a long time, and you have reached 21 years old, that's it, they updated, and now you have to wait longer because now you're over 21. I think if it was filed before 21, then throughout the whole process of basically, family reunification process, it should stay in the category under 21 because the priority date, because it was filed when you were under 21. But the government does not agree with me at the moment. Congress does not agree. So I really hope that somebody who understands this a little bit better one day will be in Congress, maybe. Probably not going to happen. But Jen, unfortunately, now you have to deal with the F2B category. It's ridiculous. It's silly. But keep in mind that it's the same goes for the situations where, because we're talking about parents in this situation, parents becomes a U.S. citizen, and now you're able to switch from F2B to F1. So from second priority to the first priority. There isn't much difference between the F1 and F2B. I do actually have the video comparing the two, but it's also a possibility that will happen. Okay, let's move on to the next comment from Therese Belido. Therese, you're very welcome. Therese says, thank you for the answer. You're very welcome. Hopefully my answer was helpful. Moving further to Sushil Nepali. Hi, for my wife and kid, should I file 2 I-730 form for each? Great question, Sushil. Thank you very much for asking. So, I am pretty sure that you do have to file separate I-730 for each one. But I'm going to use this as an opportunity to demonstrate some navigation on USCIS once again. This is a homepage for USCIS. You can find the link for this website in the description of this video. We're going to click on Forms. We're going to click on All Forms. and we will find, you can scroll down, find 730, but I will type in 730 here, and this should come up right away. There we go. So we're going to click on this. This is the page, official government page for specifically for the I-730 petition. We're going to go to instructions, and in the instructions, because it's a PDF document, you can search within it. You can try to find it different ways, but I'm going to try to find the word separate because I think this should come up. So there you go. That's it. We got our answer. Who may file Form I-730 if you have been admitted to the United States as a refugee, or if you have been granted status in the United States as an asylee, and you were the principal applicant for your family, you may file Form I-730 Refugee Asylee Relative Petition, provided that your refugee admission or asylum grant occurred within the past 2 years. That's one of the requirements. It has to be within the past 2 years. Approval of Form I-730 for a relative abroad does not guarantee visa issuance. A separate Form I-730 must be filed for each qualifying family member for whom you are petitioning. So yes, Sushil, you will definitely be filing a separate I-730 petition. Thank you for your question. It was a good one. Let's move on to the next one from Starsha. Sorry for mispronouncing the name. Merit. What do I need to put in my package for spousal application? Alrighty, Starsha. So I'm assuming that you're referring to the I-130 petition, which is the petition for alien relative. And yes, you do start that petition for your parents as a U.S. citizen. You can start that petition for your brother or sister as a U.S. citizen. You can start that petition for your spouse, your kids as a petitioner, as a U.S. citizen, and the permanent resident. So that would be I-130 petition for alien relative. I do have a whole separate video on the whole process from start to finish, filing the I-130 petition with USCIS, and then your case transferred to the NVC, and then transferred to the US Embassy for the interview. So all of this you can find on this channel. You can start with the video that describes the full process from start to finish, and then I do have separate video for each individual process. The actual application, filling it out, submitting the documents, the NVC, becoming documentarily qualified, and then the actual interview. So to answer your question in detail, we're going to go to the same place. We're going to go to forms, all forms. I'm going to find I-130, and I will tell you the initial stuff that you will have to include in your application. Now, the good news is that the I-130 can be submitted online, and I would highly recommend submitting it online because it makes the process much easier. So all of the documents that you have, you will be actually uploading in the electronic form in the online application. So it makes it much easier, much faster. So let's take a look. Checklist for required initial evidence. There we go. So here are a few things that will be required in order to provide with the initial application package. Evidence of U.S. citizenship or lawful permanent residence or U.S. national. That would be for the petitioner, obviously, if they're permanent resident or U.S. citizen. It can be birth certificate, it can be naturalization certificate, it can be the permanent residence card, obviously green card, all right? Evidence of family relationship. So we are talking about spousal relationship, so that's going to be a marriage certificate. That's really it. Evidence of bona fides of the marriage if petitioning for a spouse, documentation showing joint ownership of property, a lease showing joint tenancy of common residence, documentation showing that you and your spouse have combined your financial resources, birth certificates of children born to you or spouse, if you have children, affidavits sworn to or affirmed by third parties having personal knowledge of the bona fides of the marital relationship, any other relevant documentation to establish that there is an ongoing marital union. So just a marriage certificate, it's not enough for them, for USCIS. They also want the bona fide documents showing that there is really a marriage relationship going on. Proof of legal name change if applicable, and 2 passport style photograph if applicable. Again, it's going to be, the online application will tell you. One thing that I'll tell you as a recommendation, Starsha, is start the I-130 petition as soon as possible. Don't wait too long, because it does take some time to wait whether you're in F2A or IR, immediate relative, if the petitioner is a US citizen, it still takes quite a long time to process because you're filing it to USCIS, you're waiting for their approval, and then you're sending it to NVC, you're waiting to become documentarily qualified, and so far so forth. There is a process that is involved. So the sooner you do it, the better it's going to be. Alrighty, let's move on to the next question comment from Juan Leonardo. When I tried contacting USCIS, I can never reach a live agent and ended up that my call is dropped. Please help. Juan, unfortunately, that's the case with USCIS. That is unfortunately how it is. It's becoming, I would say, it's becoming every time harder and harder to reach the agent. There was one way one way to reach a live agent. It was through basically when you call, they ask you if you want to find any specific form. You tell them yes. They ask you which form. You give them which form you're dealing with. In this situation, sounds like you're dealing with I-130 because you're asking on why my case. Although it can be any other form, honestly. But whichever form that you're dealing with, just select that form, and then they will just keep giving you all this information. Just wait for the full prompt until it's done, and then they will ask you if you have any additional questions. Just say yes, and then they would connect you with a live agent. I don't know if it's still the same thing that you can do, but this is one of the ways that I personally, because I myself am an immigrant, that's how I would get to that live agent. But another thing that you can do is, if you cannot reach the live agent, and if the situation is not looking good and the case is taking long, because that's what you're concerned about, that's what you're asking, submit that case inquiry, just like I showed in this video. Just go submit the case inquiry, say that it's outside of normal processing times, and you will get the response from USCIS. A lot of times the response from USCIS is going to be very boilerplate. It's not going to give you a lot of information. But once you do have that response from USCIS, you can actually start looking into another avenues of finding support. Not from USCIS, but from possibly local elected officials. We're talking state representatives, senators, and I have seen some situations where reaching out to elected officials actually helped the situation. So I would definitely recommend you looking into that. Alrighty, let's move on to the next question from Trudy Bubs. Trudy, thank you very much for another question. Appreciate that. Hello, sir. Thanks for answering my question. Of course, anytime. I do have another question. If it's a case where the Visa Bulletin do not move, does that mean I will not get my interview date? Because I'm F1 of US citizens and the Visa Bulletin has not changed from December 2014, over a year now, and I have been documentarily qualified from 2021. Truly, so unfortunately, whenever it comes to, whenever we see the lack of movement, but before I even begin, let's look at the Visa Bulletin and see what it looks like as of right now, and then I'll explain what's happening when the Visa Bulletin is not moving a month every month, because that's what we should expect, right? So we're looking at the Visa Bulletin. Let's actually get your example. So your F1 has not changed. You've been documentarily qualified since 2021. So do not change from. So I'm assuming you are in December 2014. No, you can't be December. Yes, so you are December 2014. December 2014 priority date. That's what it's showing for F1. So I don't see. So you've been documentarily qualified since 2021, which is 2 years. Okay, so I don't remember what your priority date was, Trudy, but I am thinking that your priority date should have been somewhere back in around 2014, around December 2014. So, with that information, when you're looking at the Visa Bulletin, so let's say right now, as of June 2023, this right here shows December 2014, which supposed to mean that people with the priority date back in December 2014, their immigrant visa is becoming available as of right now, May, June 2023. So naturally, in July 2023 Visa Bulletin, we should be seeing January 2015 here. 1 month move, 1 month move. Unfortunately, that's not how it works. That's why we see this backlog growing more and more and more, because more immigrant, applications, more petitions, the more of the backlog. And a lot of times, like for example, with this situation from May to June 2023, there was absolutely no movement on the Visa Bulletin. And we expected at least 1 month's movement on all of the categories. When that happens, then yes, you do know that it's still being processed. It still is moving, all right? The immigrant visas are becoming available, but they're just not becoming available fast enough for the Visa Bulletin to move 1 month each month. So it does not mean that your immigrant visa is not going to be available in the next few months, but it's just not going to be available as fast as we predicted with the Visa Bulletin, unfortunately, because every month it's not moving a whole month, all right, if that makes sense. So sorry about that, really sorry about that. I myself am dealing with this stuff too. I do have a petition that I'm waiting on, so I definitely understand how it feels. But you should be very, very close, because you are already documentarily qualified. You should be really close. And if you are current on the Visa Bulletin, if you see December 2014 and you have your priority date in December 14, I would definitely recommend reaching out to NVC. Just keep reaching out to them and ask them, hey, I am current on the Visa Bulletin. I am documentarily qualified. When will my interview be scheduled? Just so that they know that you're checking, you're on top of that, and you're not just letting the case go into their hands and they do whatever they want to do. So thank you very much everyone for tuning in for today's video. Like I said, if you have any follow-up questions, do not hesitate to ask them. Just make sure don't respond to my comment within your comment, because YouTube does not send me those notifications. Always appreciate your time. God bless, and I'll see you in the next video.